On August 14, 1935, President Franklin D. Roosevelt signed the Social Security Act. Its provisions included old age benefits and payroll taxes to help finance them. The President made a brief statement.
To 30 millions of our citizens who will reap direct benefits through unemployment compensation, through old age pensions, and through increased services for the protection of children and the prevention...
The payroll taxes were to start in 1937. But months before that, in Boston, Massachusetts, in federal district court, an action was begun by attorneys for George P. Davis, a shareholder in the Edison Company of Boston. He was suing for an injunction to restrain his company from paying the Social Security taxes. He argued they were unconstitutional. His claim cited a 1935 Supreme Court decision. This had to do with the Railroad Retirement Act of 1934. It had established a plan very similar to Social Security: payroll deductions, matching contributions by employers, all this going into a huge trust fund held by the government, and later, on retirement, monthly old age payments. But the railroads had contested the law, and the issue went to the United States Supreme Court. The decision, a 5-4 decision, was read by Justice Roberts. He said, "The railroads, though dedicated to public use, remain private property, and their assets may not be taken without just compensation. There is no warrant for taking the property or money of one and giving it to another." Petitioners constantly recur to such phrases as employee morale, fear of old age dependency. These matters obviously lie outside the orbit of congressional power. Thus, the Railroad Retirement Act of 1934 was declared void. The court seemed to say, no such act can be found valid. Yet, just a few months later, President Roosevelt was signing a law vast in scope and startlingly similar in design: Social Security. Could it possibly survive a constitutional challenge? If the President had doubts about it, he did not show them. Yet he had reason to doubt, not only as to Social Security, but as to other New Deal laws as well. In district courts throughout the land, not only in Boston, but also in San Francisco, New Orleans, Houston, Savannah, and elsewhere, injunctions were being asked and granted against various New Deal laws. Slowly, the cases were making their way toward the United States Supreme Court. Here is a partial record of such actions during 1935 and 36. In the spring of 1935, soon after its ruling on railroad retirement, the Supreme Court took up the NRA, the National Industrial Recovery Act. This, one of the earliest New Deal acts, was designed to help industry out of its disastrous deflation, end unfair competition, and raise wages. But the Supreme Court ruled it void, as involving, for one thing, an unconstitutional delegation of legislative power. The vote was unanimous. A few months later, the court took up the Agricultural Adjustment Act, also passed in 1933. Through this law, the administration tried to limit farm production and conserve the soil while bolstering farm prices. In January 1936, the court declared the act void as an improper use of the taxing power. 3 justices dissented. Presently, the court considered the so-called Guffey-Coal Act, an attempt to stabilize a basic industry torn with strikes and dissension. In May 1936, the court found it void, as beyond the power of Congress under the Commerce Clause. 3 justices dissented. In the same month, the court considered the Municipal Bankruptcy Act, an attempt by the federal government to assist communities facing insolvency because of falling revenues and mounting relief costs. In May 1936, the court found the act void as an encroachment on state sovereignty. 4 justices dissented. Thus, in a few short months, key portions of the New Deal program had been torn to shreds through court action. On the basis of past decisions, a number of other measures seemed doomed. Among them, certainly, the Wagner Labor Act and Social Security. It was an election year. Early in June, the Republicans met in Cleveland and nominated Alfred Landon of Kansas and Colonel Frank Knox. Later in the same month, the Democrats in Philadelphia renominated Roosevelt and Garner. During the following campaign, the Republicans often spoke of the court as the bulwark of our liberty. Roosevelt, for the moment, said little about the court. He spoke mainly of the aims of his program. In November, Roosevelt and Garner carried the rest. Once more, Roosevelt rode to office on his pledge of a New Deal. But could he carry out that New Deal program?
And will, to the best of your ability, preserve, protect, and defend the Constitution of the United States. So help you God.
I, Franklin Delano Roosevelt, do solemnly swear that I will faithfully execute the office of President of the United States and will, to the best of my ability, preserve, protect, and defend the Constitution of the United States. So help me God.
It was rumored that Roosevelt, battling for his program, had a plan to reform the courts, including the Supreme Court. 2 weeks later, he sent his proposals to Congress and later explained them to the people.
We have reached the point as a nation where we must take action to save the Constitution from the court and the court from itself. We must find a way to take an appeal from the Supreme Court to the Constitution itself. We want a Supreme Court which will do justice under the Constitution and not over it. In our courts, we want a government of laws and not of men. What is my proposal? It is simply this. Whenever a judge or justice of any federal court has reached the age of 70 and does not avail himself of the opportunity to retire on a pension, a new member shall be appointed by the President then in office with the approval, as required by the Constitution, of the Senate of the United States. Why was the age...
A justice reaches 70. If he does not retire, an additional justice is added. When and if he does retire, the number returns to 9. In 1937, there were 6 justices over 70. Thus, under the proposed law, the President would be able to appoint 6 extra. If the older justices decided to retire, the total number would return to 9. Throughout the land, debate began. The newsreels covered the story.
Roosevelt's plan to change the Supreme Court has become the greatest public issue since slavery. Patty News brings you this exclusive statement on the Supreme Court itself by Chief Justice Hughes.
The justices of the Federal Supreme Court are not merely titular successors in important official duties, but inheritors and developers in a continuous process of exposition. And thus they enter with a lively consciousness of fellowship into the problems, the anxieties, and the achievements of those who have preceded them in their necessary but difficult task as weavers of the fabric of constitutional law.
Roosevelt considers the overwhelming vote which returned him to office as a mandate to carry out his policies, even to changing the Supreme Court. but many of those who voted for him are against him on this issue. Throughout the country, those for and those against the plan are lining up for the finish fight in the United States Senate. Leaders of the opposition, Democrats and Republicans alike, reply to Roosevelt's challenge.
There can never be a dictator in America while we have a Constitution and an independent court.
Our fathers feared the tyranny of an unchecked sovereign.
If the Constitution needs changing, let it be changed by the people. It belongs to them alone.
Hands off the Supreme Court.
Every man, woman, and child of this country will be affected as a result of the fight now raging in the Senate. The Constitution is not what the judges say it is. The Constitution is not what a president says it is.
While the dispute raged, the country began to examine more closely this unique institution. Now, in 1937, another Congress was discussing the power of the court, a court which seemed to many a threat to the recovery program. Now, a different method was under discussion for dealing with this problem. The reason for this was clear. Observers noted that when the court was divided, the divisions often followed a pattern. Justices Vandevanter, Sutherland, McReynolds, and Butler were inclined to vote together. They usually interpreted very strictly the clauses in the Constitution which define the powers of Congress, such as the taxing power and the power to regulate commerce. On the other hand, Justices Brandeis, Cardozo, and Stone also tended to vote together, interpreting more broadly those same clauses. The first group was often called conservative, the other liberal. In between them were Chief Justice Hughes and Justice Roberts. Sometimes they voted with one group, sometimes another. Early in the New Deal, both voted to uphold the government's money policies when gold payments had been suspended. But in the railroad retirement decision, Justice Roberts voted with the conservatives. In the decision on the Agricultural Adjustment Act of 1933, Chief Justice Hughes did too. In the municipal bankruptcy decision, Chief Justice Hughes was back on the liberal side. And so it went. Chief Justice Hughes and Justice Roberts. They seemed to hold the key. Momentous national issues sometimes hung on two men, or even on one. Throughout our history, this has often been the case. It is not astonishing, perhaps, that administrations have sometimes yielded to a temptation to change the number of judges. The Constitution does not forbid such changes. It only says, the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as Congress may from time to time ordain and establish. The details are left to Congress. At first, Congress established a Supreme Court of 6 justices. In 1801, Congress passed a law that the number should, after the next vacancy, be kept at 5. The Adams administration apparently hoped that Jefferson, as a result, would not have a chance to appoint a justice. But under Jefferson, the law was repealed, and 6 years later, the number was changed to 7. In 1837, because of the growth of the country, the number was increased to 9. And in 1863, under Lincoln, to 10. Then an act of 1866 provided, for clearly political reasons, that the next 3 vacancies should not be filled. But the number had only dropped to 8 when a new law, in 1869, changed it to 9. Thus it stood until Roosevelt, in 1937, proposed a new change. In Congress, some people, while critical of the court, were just as critical of the man. Meanwhile, in the lower courts, legal battles against New Deal measures continued. Several suits attacked Social Security. To the New Deal, these were of special concern. Already, at offices set up to administer the new law, 26 million Social Security numbers had been established. On January 1st, 1937, 26 million employees had begun to build up credits toward old age benefits. The first applications for benefits were being received and processed. Would all this machinery, this huge new organization, presently have to be dismantled? Eventually, the Supreme Court would hold the answer. Here, the New Deal was at the crossroads.
My friends, neither individually nor as a party can we postpone and run from that fight on the advice of defeatist lawyers. Here is 1/3 of a nation, ill-nourished, ill-clad, ill-housed. Now, here are thousands upon thousands of farmers wondering whether next year's prices will meet their mortgage interest. Now, here are thousands upon thousands of men and women laboring for long hours in factories.
The president fought hard. Many observers doubted he could win the battle. Then there came, from the United States Supreme Court, a puzzling development. A Washington state minimum wage law was up for decision. It had been assumed, on the basis of previous decisions, that Justice Roberts would vote with the so-called conservatives. He didn't. Neither did Chief Justice Hughes. Later, the same vote upheld the Wagner Labor Act. What did this mean? Would the pattern continue? On May 24th came the answer, the decision on Social Security. One part was upheld by the same vote, 5-4. Another by 7-2. At the Capitol, one senator said, "This puts the last nail in the coffin of the court bill." The court bill was defeated. At least the Roosevelt plan, the so-called court packing plan, went down to defeat. Some observers put it this way: the president had lost the battle, but won the war. A month after the Social Security decision, one of the older justices, Justice Van Devanter, retired, to be followed soon by others. The complexion of the court began to change, and so the curtain came down on this group, perhaps also on an era. The New Deal had turned the corner. The men who wrote this document lived in an agricultural society. It is a measure of their wisdom that their plan of government still provides us with a workable framework for decision. Yet the transition from an agricultural to an industrial nation has subjected the Constitution to countless stresses and problems of interpretation. This film dealt with one of those many problems.
This is National Educational Television.